inner keys.
Good morning. I'm going to give it a couple more minutes. Okay, so we can go ahead and get started. Maybe. Okay, so last time we finished talking about the rights in the Bill of Rights. Specifically, we talked about Amendments 5 through 10. And we also talked about how the Bill of Rights originally was meant as a protection it was meant only to limit the national government, not the state governments. And we also talked about the case of Barron versus Baltimore. In 1833, the Supreme Court reiterated that point when Mr. Barron tried to sue the state of Maryland for ruining his business, and he tried to sue saying that they owed him just compensation, trying to use the takings clause of the Fifth Amendment. The Supreme Court said, well, yeah, I see what you're saying. That does amount to a take, but the Bill of Rights, the takings clause of the Fifth Amendment only applies to the national government, not to the state governments. For protection against your state government, you have to look to your state Bill of Rights. So the general rule of law that comes out of that is that it was a reaffirmation. The Bill of Rights only applies to the national government, not to the state governments. So that's what we covered last time. Administrative announcements. There's Quiz 2 will be open next Thursday, September 17th through Saturday, October 19th. There'll be just probably a few more multiple choice questions than there were this time. The study guide is posted. It's about the rights in the Bill of Rights. And I posted something, let me show you something that I posted in the D2L page. Let me just navigate there real quick. I say real quick, but okay. So if you go to, oh, and let me, it's more like a book for you. And go down to quizzes. I posted the study guide for quiz 2, but I also posted something to help you study for it. This is just another copy of the Bill of Rights, but I also included over here in the left margin each of the individual rights in the Bill of Rights. I just thought it might make it a little easier to study for the quiz. So you can use that document to help. Okay, so back to, so today we're going to continue to talk about, okay, the Bill of Rights applied to the national government, not to the states, but we're going to talk about why that was and how the people who wrote the Constitution kind of imagined the world was going to be. And then we're going to start talking about how the 14th Amendment really changes everything in terms of the relationship between the state governments and the federal governments in the Constitution. So, you know, we know that we have rights, and Americans especially use the language of what's sometimes called right talks. You know, we'll wander around saying, hey, I have a right, you can't do that, I have a right to this, and I'm going to sue you, I have a right to that. And so rights are simply a legal tool that protects you, but we have, and we know that, but we have a much bigger idea of what the specific rights are, but more importantly, who or what does the Bill of Rights and rights protect us from in general? And so I wanted to talk about that for a minute. And I would like to do that with pictures. Okay, so there's you. You're wandering around saying, yeah, I got rights. So if we think about, okay, what are the things out there that can burden liberty so that, you know, your rights become infringed? Well, one of them we know in our system would be the federal government. You know, the federal government has all this power, and that's kind of scary. And it certainly has the power to burden your liberty. But our system also has state governments, and state governments can also burden your liberties. Then there's even one more entity out there that could burden our liberties, which is society. If society decides they don't like us, then, you know, society becomes yet another thing that can end up taking our liberty from us. And so if we imagine that the Bill of Rights is sort of like a shield, the way our constitutional system was originally designed is that shield was only a protection against the national government. It wasn't a protection against either one of these. And so that's where we were right after the Bill of Rights was added to the Constitution. We were still there in 1833 after, you know, the Supreme Court reiterated that principle. And remember, when the Supreme Court talked about, well, how do we know that that's what they meant? They used a historical kind of an originalist analysis, and they said, well, the reason they wanted to add a Bill of Rights was because at the ratification debate, some people thought that the national government had too much power, and they said, you know, you've got to put a list of individual protections in there. And it also, if you look at the language, a textualist argument of the Constitution, it's a document about the national government. And so it starts out talking about the national government, and the default position is that the Constitution is about the national government. When it talks about states, and it does, it specifically says, oh, this provision is about states. And so likewise in the Bill of Rights, it starts out, Congress shall make no law regarding an establishment of religion. It's talking about the national government, and then it's about the national government all the way through, including in the Fifth Amendment's taking clause. It's not about Maryland, but then at the end in the 10th Amendment, it does want to mention states and their reserved powers. It talks about states when it's going to talk about states. Otherwise, the document is about the national government. Okay, so we know that eventually this changes, but why would they have designed it this way? And so here's when they were writing the Constitution, they had in mind the fact that a government, what they believed was a democratic government that was close enough to the people would not become a tyrant, because the people, if the government is small enough and states were small enough that everybody would feel a part of one society, and that the government that you had to watch out for were governments that were further away. And eventually it feels like us and them. And what they had in mind, of course, was the colonies and Great Britain. So when they were thinking about the national government, which they wanted to have this national government for certain things, you know, defense and trade and so forth, but they knew that eventually the national government, if you're going to worry about a government, the one that's further away from the people is going to be the one that you worry about. You know, when before the War for Independence, colonies were just part of the British people, but eventually the colonies felt different. They said, you don't understand us way out here. You're far away from us. You don't know who we are anymore. And so they thought it's governments that are far from the people that are abusive of rights, which is why they were careful to craft a government that had those, only the powers given it, as well as then through pressure, they added the Bill of Rights. So they were imagining a system where the federal government had some potential to be abusive of rights. And they had in mind, you know, they were thinking of Parliament and the King and that being really far away. But these separate units, they thought these will be close to the people. State governments, because they're of the people and they're small, they're not going to abuse the people's rights. And each of the state governments has a Bill of Rights. You know, you still need some protections, and state constitutions had their own individual lists of rights in them. They just simply didn't imagine a time when it would, not only would it be the state governments that are violating people's rights, they didn't imagine that there would be a time when the national government would actually want to be protecting citizens from their own states. They just didn't imagine that. And so there was no such mechanism for that to happen. So in our original system, of course, you know, we had this shield added, the Bill of Rights, that was protecting us against the federal government, but the national constitution, I mean, state constitutions had them, but they just didn't think there'd be a time when both the states were violative of rights and the national government would actually want to do the right thing. But then in the post-Civil War era, all of a sudden you have states in a wholesale way violating the rights of about a third of the population in very dramatic ways. And we'll talk about some of those ways. But they systemically, it wasn't just here and there, they systemically were violating the rights of the newly freed slaves. And at that time, there was not a mechanism that would allow the federal government to come in and protect people from their state governments. You know, as the states were pretending like the Civil War didn't happen and going about their business, not just violating the legal rights of African Americans, but in very brutal ways violating the rights of African Americans. And, you know, Congress was watching with horror as this was unfolding. There was no mechanism in the Constitution as it was written that allowed the federal government to do anything. And so that's where we're going to start our next conversation, because the 14th Amendment ends up radically, not right away, but eventually, it was meant to change the relationship right away. There was a lot of resistance, and at first the Supreme Court and its weak interpretation of the 14th Amendment was part of the problem, but eventually the 14th Amendment would offer would change that relationship, and there would be a way that the national government could come in and protect people from their state governments. Okay, so after the Civil War, well, and we actually need to talk about another case. And I'm going to experiment with using the whiteboard. So we're going to talk about a case called Dred Scott versus Sanford. That was in 1865. Is that right? Yeah. 1857, sorry. So we're going to talk about this case because, you know, after the Civil War, there were 3 amendments that collectively we refer to as the Civil War Amendments. And we needed at least 2 amendments to undo what the court did in Scott versus Sanford, because it set up a situation that it was really a low point in terms of any kind of legal protection for African Americans. So I'm going to put the principle that comes out of the case up here, and then we'll talk about how we got there. So basically, it says that it sets up the idea of dual citizenship. And it says that everybody has 2 kinds of citizenship: state citizenship, federal citizenship. And it says that Blacks, whether free or slave, cannot be US citizens. And then secondly, it says, the court said that it is unconstitutional for Congress to outlaw slavery. Okay, so how did they get there? So, and this will involve a little bit of drawing. So prior to, so if this is the United States, that's a map, yes. And sadly, if I was in person using a chalkboard or a whiteboard, my drawing of the United States would not be that much better than this one. But prior, after they created the Constitution, there was always this political tension between the free states in the North and the slave states in the South. And they were very jealous of political power in Congress. And so they wanted to try to keep that roughly balanced and to kind of keep the status quo. So in the Constitution, it says that they set out a process for states to be, for territories to become states. So, you know, after a territory has a certain number of people living there, they can apply to Congress and ask to become a state. And then Congress passes a law, it's called enabling legislation, that specifies what that territory has to do to become a state. So as if you look, there was a line they drew, which was kind of near the Mason-Dixon line, well, not exactly, but as states were admitted north of that line, Congress in their enabling legislation was silent on the question of slavery. But states that were admitted south of that line their enabling legislation said that I'm sorry, I said it backwards. The southern states, they didn't say anything about slavery. And so the southern states all had slavery. The states north of the line, when Congress wrote that enabling legislation, it would say, you can't have in the state constitution that you submit to us, it cannot, you have to prohibit slavery. And because they wanted to keep that balance about the same, so that in Congress, especially the Senate, you wouldn't get a lot more power for either the slave states or the free states. And so you kind of had that balance. So let's move up and talk about the facts surrounding this specific case. There was a guy named Dr. Emerson. Yeah, I suppose I should type it in, but yeah, we're going to have to type it in. I can't draw that well. Dr. Emerson owned Dred Scott and his wife. And they lived in Louisiana, which was, not Louisiana. Geez, all of a sudden, old age is a hellacious thing. All of a sudden, I'm going to have to Google and say, what state was Dred Scott in? Sorry about that. It's the first time I forgot. Missouri. I was thinking Missouri. Okay, so we'll put Missouri. And that's not the correct, that looks like Mississippi or something. But they lived in Missouri. Dr. Emerson was an Army surgeon. Dred Scott was his domestic slave. And meaning, you know, he did things around the house. He ironed his clothes, that kind of thing, did all those personal things for him. And so when Dr. Emerson got stationed for a little while up in Illinois, and yeah, that's the abbreviation for Illinois, he took Dred Scott with him. And they were up there. He served, the Army had him serve there for several months. Eventually, they returned back to Missouri. Dr. Emerson dies. In his will, he left Dred Scott and his wife to Mr. and Mrs. Sanford. And that's how they get in the case. And they're in New York. So obviously, New York is a free state, so they can't, you know, Dred Scott as a piece of property is, you know, can't go work in New York for Mr. and Mrs. Sanford. And Mr. and Mrs. Sanford was Dr. Emerson's sister and her husband. And that was who he left all his estate to. But they could sell Dred Scott, and that was not and his wife, that was not an insignificant amount of money. Indeed, if they had sold them, they would have gone for somewhere between the two of them as adult slaves, maybe somewhere between $800 and $2,000, and that would be like $100,000 to $300,000 today. So it was not a trivial sum of money. So they were going to sell, but some abolitionist lawyers sued on behalf of Dred Scott to try to win his freedom. And they used a doctrine that had developed in Missouri courts that said, once free, always free. And this is partly why I've drawn the little illustration here. So they said, the doctrine, once free, always free. Missouri courts through the common law had said, you know what, if if there's any documentation that someone can produce that says that they were ever free, like a slave maybe bought their freedom and could show a receipt, or it was in the newspaper somewhere, we're going to assume that person is forever free after that, because there was a problem in Missouri and other states where freed slaves, whether it was because their owners freed them or they had purchased their freedom, they were always in a really vulnerable state because people would come along and essentially capture them and say, well, no, they're my slave. You did, they made a deal with me, or their owners made a deal with me. And so the courts basically said, if you can show evidence that you were ever free, we're going to assume that's the way you remain, because nobody would go back into slavery by their own accord. And so what the lawyers for Dred Scott did is they said, well, technically, when he was in Illinois, Congress made it illegal for people to have slaves in Illinois. So technically, he was free at that time. We just have to show you documentation that he had been in Illinois, and then he should be free and shouldn't be sold, and they should go about their way. So they lost in the state courts, but the lawyers made one last try to the Supreme Court. And in the Supreme Court, they filed suit under in Article 3 of the Constitution. It says that the Supreme Court can be a court of original jurisdiction in cases involving citizens from two different states. So they said, we have our citizen down here, Dred Scott, who's a citizen of Missouri, and we have Mr. and Mrs. Sanford, citizens of New York. And the Supreme Court said, actually, no, you don't have two different citizenships. The only US citizens that are in question here are Mr. and Mrs. Sanford. The court said that, you know, if states want to give Blacks citizenship, that's up to them. But Justice Roger Boutani wrote that, he said, if you look back at the time when people of African descent were brought to the United States, they weren't considered part of the polity. They weren't meant to be citizens. They had been meant to be slaves. And so they cannot be part of the political mechanism of the US government. So they can never be US citizens. Maybe they could be state citizens, but they can't be US citizens. So that took away the ability, the jurisdiction that the court would have, the Supreme Court would have. But they also went on to say something else. They said, furthermore, even if we were going to allow this to go forward and say that he was a US citizen, he was never really free when he was living in Illinois, because they said Congress all this time hasn't had the power to outlaw slavery. And ironically, they used the Fifth Amendment's taking clause and the due process clause, because they said if a Southern slave owner wanted to move up to a free state, Congress would basically has been stripping them of this property with their slaves without due process or without just compensation. And therefore, all of those laws Congress had passed all that time were now null and void, because Congress didn't have the authority to limit slavery. And so, among other things, I mean, this case has a lot of meaning. Part of it was a really low point in terms of constitutional and legal rights for African Americans. Partly, it was it made political compromise impossible between the southern and northern states anymore. So it kind of probably hastened the Civil War. I mean, it didn't create the bad feelings, but by saying there can no longer be political compromises, it probably hastened the Civil War. So after the Civil War, then Congress, you know, the president couldn't just declare that someone was free. Congress couldn't declare that someone was free because the court had said it's illegal for Congress to outlaw slavery. So there's two kinds of interpretations the Supreme Court or any court makes. the court sometimes does statutory interpretations, and that's where it's clearing up what the meaning of a statute, a regular law is. It also, courts do constitutional interpretation, where it's clearing up what the meaning of the Constitution is. When the court makes a statutory interpretation, if Congress doesn't like what the court says and disagrees with it, like if they've passed a law and the court says, this is what that law means, and Congress says, no, it's not, all it takes to undo what the court did with statutory interpretation is pass another law and say, actually, the court had it wrong, we mean this, another law takes care of it. When the court interprets the Constitution, it can't be undone just with legislation if Congress doesn't like it. So if the court says, this is what the Constitution means, it can only be undone with a constitutional interpretation. And so they couldn't, Lincoln's Emancipation Proclamation was problematic in a lot of ways. After Dred Scott, when Lincoln made the Emancipation Proclamation, according to the court's interpretation, but Dred Scott, that the federal government couldn't, Congress, but the president either couldn't get rid of slavery. And even if we didn't have Dred Scott, ironically, the Emancipation Proclamation didn't free a single slave because it freed, it was meant by Lincoln as a war measure. He only freed slaves in states that had seceded from the Union. He didn't free states in the loyal, he did not free slaves in the loyal border states. They remained slaves because he didn't want to rock the boat there. The hope of the Emancipation Proclamation was that if slaves heard that all they had to do was get to the North somehow and they'd be free, or the other thing they could do is not help the war effort and try to stymie the war, either of these things would be helpful to the Union troops. And so even if you hadn't had Dred Scott, you needed to legally clean this up. So the 13th Amendment is the first of our Civil War amendments. And let's look at the wording of that. Sorry. Okay. So if we go, and let's make this a little bigger. Why doesn't it make it bigger? There we go. We go to, oh, this one doesn't have the amendments. Great. I thought I picked a constitution that had the full. Oh, good grief. This one used to just have it in text. I swear to God, the world changes right under our feet. So, okay. So the 13th Amendment, ratified in 1865, says, neither slavery nor involuntary servitude, except as punishment for a crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. And then it said Congress shall have the power to enforce this article by appropriate legislation. After the 13th Amendment was passed, and there's a pretty big problem with the 13th Amendment. There's this huge loophole that says, except for punishment of a crime. And so what Southern lawmakers did was they used that loophole to use the criminal justice system to maintain control over the African American community. And so it went from a system where private ownership was used to control the Black community to a system where the criminal justice system was used, because states started passing a series of laws that we refer to as the Black Codes. And there were two types of Black Codes. One type of Black Code made certain things a crime just based on color. So, for example, there were laws that were passed that said that African Americans couldn't be out after dark, but that was only if you were African American, not if you were white. Or laws that said if you're African American, you must show, and you go into a store, you have to be able to show proof of employment before you go into that store. Laws that were only crimes if you were Black. But there was another type of Black code that they passed. Some things they made a crime for Blacks and whites, but they made it a more serious crime for Blacks and whites. So, for example, Mississippi had a law that if you stole a pig and you were white, it was a misdemeanor. If you stole a pig and you were African American, it was a felony. And so they had this system where they were able to make all of these things that African Americans did a crime, and they combined that with, they would arrest all these people kind of selectively, like when plantation owners needed labor, they would arrest a bunch of people. And they combined that with a system of convict leasing, which convict leasing is different than convict labor. Convict labor is considered constitutional. That just means that while you are incarcerated, convict labor means that you can be forced to work in that context. Convict leasing means that the government actually kind of contracts you out, and a private party, and says you have to work for this private party. So basically what would happen is they'd arrest people using the Black codes, and they would charge them a fine of, say, $25 or $50. The average male wage right after the Civil War was about $1 a week for African American agrarian workers. So, this typical fine of $25 or $50, a fine of $25, that's nearly 6 months work. Nobody's going to have that kind of cash, but then either a plantation owner or sometimes even contractors that were rebuilding the South would come down, and they'd pay that amount, either $25 or $50, and then the person would have to work for them until that fine was paid off, so maybe 25 weeks or 50 weeks. And so the combination of the Black codes, which made everything a crime if you were Black practically, and the use of convict leasing, where they weren't held by the government, because convict labor, at least government employees, when they are managing a prison, are bound by the laws and the Constitution in terms of due process and cruel and unusual punishment and those kinds of protections. When you are giving over the life of someone to a private party and no longer supervising that, that was a real abrogation of government responsibility, because they were arguably treated, well, we know demonstrably that they were treated worse in some of these convict labor camps, where contractors from the North who were sent down to the South with these government contracts to rebuild the infrastructure of the South, because the South was really left decimated. They had their roads and bridges had been destroyed by Northern troops. The South had often used schools as military headquarters, and those were all destroyed by the Union troops. And so Congress made a bunch of money available, and it was Northern contractors that had the wherewithal to bid on these contracts, get them. They'd go down to the South, they'd pay all these fines, and then they'd have that person available to work for them for 6 months or a year. And that was arguably worse than slavery was, because at least under slavery, that there was long-term value to that slave's life. I just said a minute ago that the value of a healthy adult slave was like in the neighborhood of $100,000 to $150,000. It was, although owners were certainly cruel and sometimes they did work their slaves to death, generally that wasn't what you did. You wanted your slave to continue to live. You didn't work them to death normally. But there wasn't that kind of investment. They had a $25 or a $50 investment. And while that would be a lot more money in our terms, they would work them beyond what human beings can work. And in some documentaries I've seen on some of these convict labor camps, in a year, the death rate was like 30% of the people. They were worked beyond what human beings can be worked. The other thing that happened after the 13th Amendment, in 1866, the Ku Klux Klan was formed, and it started. So one way of controlling the Black population was using the criminal justice system through the use of the Black codes. But another way that Southern society attempted to reassert white dominance over the Black population was just through sheer terrorism. The Ku Klux Klan was a paramilitary terrorist group that would, if you were perceived to have done something, either real or perceived, that deserved the punishment of white society, you'd get a visit from the Klan in the middle of the night. And a second visit or a serious, perceived violation could cost you your life. And there were hundreds and thousands of documented cases of the Klan coming in and pulling out a whole family and slaughtering all of them, and to really bring home the fact that this was a terrorist organization. Sometimes they would dismember people they had killed and put arms and legs on fence posts in neighboring Black communities. And the idea was, the Klan sees you, the Klan knows what you're doing, the Klan will seek its revenge. And you better know your place and not step out of line, because it will cost you your life. And so there's a situation between the convict labor camps and the Klan's wholesale violence. It had turned into this out of control, crazy bloodbath in the South with regard to the freed slaves. And so Congress, one of the mistakes that Congress made when the South finally gave up was that they didn't punish the South in any way. The Southern states assumed their full membership as states in the Union again without any kind of sanction. They said, all along during the Civil War, they kept saying, if you put down the guns and stop the warring, it'll be just like it was. We won't treat you worse than we did before. And so they became full-fledged states right after the Civil War. We have this system where the federal government, there's nothing legally the federal government can do to make the states stop acting this way. So you had this situation where Congress is just sitting, holy crap, there is no legal mechanism for us to do anything. And so they did the most radical thing that Congress ever did. Actually happened in 1867, when they passed something called the Reconstruction Acts of 1867, which did a whole bunch of things. But for our purposes, the Reconstruction Acts of 1867 took away statehood from the former Confederate states and turned them from 11 states into 5 districts under martial law, put 5 generals in charge of that area. And they said that the South would have to do a bunch of things in order to get statehood back. For our purposes, the most important thing that they would have to do is ratify the 14th Amendment, which was going to finally provide a tool for the federal government to intervene between states and their citizens when there was systemic abuse of rights, something that didn't exist in the original Constitution. I mean, this was really radical because during all of the war, Congress kept saying, just put down the guns and you'll be full-fledged members, you know, we'll work it out. But when they saw what was happening after the Civil War, with the Reconstruction Acts of 1867, it was sort of like Congress looked and said, God damn it, we just didn't kill 600,000 people to have nothing changed. And so, you know what? You are no longer states. We probably should have done this in the beginning. Here's what you got to do to become full-fledged part of the Union again. And so the 14th Amendment was the cost for states, southern states, to regain their statehood, because the 14th Amendment would never have been ratified without being coerced to. So what I'd like to do now is look at the 14th Amendment. Wait, where'd it go? And let's make it a little bigger. The part of the 14th Amendment that we're going to spend a long time on is this Section 1. But today, I'd like us to just look through, there's 5 sections to the 14th Amendment. I'd like us to look through those other sections and just see how broadly they were trying to redo things. Because all the rest of the 14th Amendment, except Section 5, Section 5 is still important to us, but Sections 2, 3, and 4 were bound in time. They were dealing with issues that were specific right to that post-war period. And I want us to go ahead and take a look at this together. And I wish the screen were a little bit better at this. But what I'm going to do is, as we read through this, I want to sentence by sentence to see if we can figure out what they're trying to say. This language is, it's not written in real friendly language that you can really see what they're going on. But as we read each sentence, I want you to see if we can figure out what they're saying and go ahead and just chime on in if you think you know what they're saying. So the second part of the 14th Amendment says, representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, including Indians not taxed. So what are they getting at there? Now we're talking about apportionment. What does that have to do with this whole Civil War Reconstruction thing? I hear somebody getting ready to talk.
Oh, sorry, that's me. The way that I take it is this is just a nice way of saying they're counting all white people. The Indians that live there don't count, and the African Americans that live there don't count.
Well, actually, you're on the right track. They're undoing the part of the Constitution from Article 1 that sets up Congress, which didn't fully count African Americans, and they're actually getting rid of that. Because if we go to, and let's...
Oh, is this getting rid of the 3/5?
Yes, absolutely. It's getting rid of the 3/5 clause. I think it... So Article 1, it says that, you know, when they're figuring out, okay, well, how are we going to count people for representation in the House? And it says representatives and direct taxes shall be apportioned among the several states. And here's how we're going to do it. we're going to add to the number of whole free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. So the whole number of free persons, that was white people, and those bound to service for a term of years, those were indentured European servants who would trade passage to the colonies, and they give a certain amount of years to pay that back. Those people were all going to be counted. And then 3/5 of all other persons. Well, of course, we're talking about the slaves. So this was actually getting rid of that. Now, the Indians not taxed, that sounds like they're also discounting, you know, the personhood and the citizenship of Indians, but actually, in the context in which this was written, it was actually acknowledging that Indians who were members of their tribes were the members of a separate sovereign that wasn't under the authority of the states or the United States. And so it was actually an acknowledgement of tribal sovereignty.
So it's like counting Indians that weren't, you know, necessarily in their own groups and more lived kind of in the state government sphere as just among
Right.
the rest of the population.
Right. So Indians that were no longer living as members of their tribe and off of the reservation, they would be counted. And that Indians not taxed, by not taxed, they were meaning they're not taxed by the state or federal governments because they're their own sovereign. And so that was actually a recognition of Indian sovereignty. Although to our ears today, without that context, it sounds like they're just not being considered. So yeah, so we needed this to undo another part of the Constitution, because remember, Congress can undo a statutory interpretation just with legislation, but if it's in the Constitution, it takes a constitutional amendment to undo it. And then let's see what they're doing here. When the right to vote at any election for the choice of electors for president and vice president of the U.S., representatives in Congress, executive and judicial officers of state, or members of the legislature is denied to any of the male inhabitants of such state, being 21 years of age and citizens of the U.S., or in any way abridged except for participation in rebellion or other crime, the basis of representation therein shall be reduced in proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years. Wow, I mean, it's almost like you couldn't say that any more awkwardly. But what are they trying to do here? And you can be forgiven if you're saying, I don't know. But some of you might. This is prior to the 15th Amendment, which said that states couldn't deny the right to vote on account of race. Here, what they were doing, this is prior to the 15th Amendment, they were trying to do this in a more subtle way. They were trying to discourage disenfranchising African Americans, because basically they're saying the amount of people that you deny the right to vote, we're going to, whatever, like if you deny the right to vote to 30% of your population, the representation is also going to be reduced in the House of Representatives. So that's fine, states, you know, yes, the Constitution says you get to set the rules about who votes, but we're thinking that maybe if you can't count them then in terms of representation, then maybe that will be some sort of motivation to let everybody vote. Okay, so Section 3. No person shall be a senator or representative of Congress or elector, president or vice president, or hold any office under the U.S. or under a state, having previously taken an oath as a member of Congress or as an officer of the U.S. or as a member of a state legislature, etc., to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. So what are they saying here? And again, I think it's almost like their goal was, let's make it so nobody will be able to understand it because we're going to word it really awkwardly. Basically, they're saying, if you've ever held office, anybody who takes office in the U.S. at the national or the state level takes an oath of loyalty and that they'll uphold the United States Constitution. If you've ever taken that oath and then you participated in insurrection or rebellion, you can't hold public office. Now they're saying maybe later on we'll take that away by 2/3 vote of each house. But for now, guess what? If you have served as a public officer and therefore you took that oath, we're saying you can't serve in elected office for now. Maybe forever, but at least for now. And then Section 4 is the one where you can see that Congress is probably thinking, okay, we've restructured some things that needed to be structured, but it's almost like in Section 4, the members of especially, the North, well, and actually it was just the North that was members of Congress at that point because states had had their statehood taken away until they ratified the 14th Amendment. But you can almost see them saying, now let's just have a little fun. Because they say the validity of the the validity of the public debt of the U.S. authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. What does that mean? Essentially, they're saying, okay, after you ratify the 14th Amendment, yeah, you're going to get your statehood back and stuff. But guess what? Not only are we going to listen to this nonsense, where you don't want to help pay for the war, you can't even question it. We're paying the debt, period. People who, foreign countries, England, who lent us the North money for the war, individuals who lent money for the war, they're all getting paid back. And guess what? It's not even ever going to be brought up as a question. They're getting paid back, case closed, period.
Didn't England pledge support to the South?
Well, it was kind of a mixed bag. France supported the South.
I know, I'd heard that, something along the lines of, and this is always simple because it's, more like middle school history kind of, but America, or the Union had kind of appealed to England because, they've been against slavery and outlawed it, so we figure they'll be on our side. But they rely so heavily on, cotton and tobacco that they had more support for the South.
Sure, but they lent money to the Union, even though, and now some rich British businessmen lent a lot of money to the South. But England itself, I think, gave some money to the North. France gave money to the South. And I may have, some of that wrong, but in essence, they were saying, if you internationally lent us money, that debt is good. We're going to make good on that. But then they go on to say, but neither the United States nor any state shall assume or pay any debt or obligation incurred in age or insurrection of rebellion against the United States, or any claim for the loss of or emancipation of any slave. All such debts, obligations, and claims shall be held illegal and void. So they're saying, okay, those of you who, France maybe thought it was funny, and they lent the South some money, screw you, you don't get that money back. And so it was sort of like this frustration was just bubbling over. Now, sections 2, 3, and 4, those are things that some housekeeping where the Constitution needed to change and stuff, and then some things that were specific to the time. But section 1 and section 5 are the parts that are important to us, and this part remains important to us. Congress shall have power to enforce by appropriate legislation the provisions of this article. So in the first part of the 14th Amendment, where they're going to say that states had to do some certain things different, it's no longer they're not just saying, oh, it's a nice thing and states are going to treat people better. It is now saying that Congress has the power to enforce it, and that would include by military enforcement if necessary. So it was trying to put some muscle behind it. They were trying to take that situation where there was no mechanism that the federal government could intervene if states were abusing the rights of people.
Can you scroll back up to read it again?
Sure. The Congress shall have the power to enforce by appropriate legislation the provisions of this article, saying it's giving Congress the power to enforce the rest of it. So the part that we're going to spend the most time with is Section 1. So it's got 4 parts for our purposes. It defines U.S. citizenship. It promises privileges and immunities to all U.S. citizens. And then it has a due process clause and an equal protection clause. So it says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. That part is, in the context in which this is written, where the Klan is perpetrating wholesale violence on the African American community, you might be thinking, okay, so why are they starting out with this definition of citizenship? Well, they had to undo what the court had done in the Dred Scott decision, where they said Blacks couldn't be U.S. citizens. So they basically are saying, okay, get this, anyone born or naturalized in the United States. And naturalized simply means the process that Congress sets out if you weren't born in the United States to become a citizen. So anyone, basically for our purposes here, anyone born in the United States, they're a citizen of the United States. Dred Scott is no longer the current law because the Constitution defines what citizens are. Every African American is a citizen, case closed, period. And then it says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So they're saying, and these citizens of the United States, which includes African Americans or anyone else born in the United States, they have all the same privileges and immunities of any other citizens of the United States. There's been a lot of argument over exactly what the privileges and immunities clause means, but at the very least, they were saying, look, all citizens get the same set of privileges and immunities as any other citizens. There aren't going to be classifications of citizens. And then they go on to say...
Can I ask something quick?
Sure.
I was just wondering if there was any, since a lot of this time it kind of focused on racial tension between, white and Black Americans, since there was post-Civil War. But was there, because we'd kind of mentioned, we'd mentioned, Native Americans earlier. Was there any, I guess, hiccups when it comes to, how this also kind of applied immediately to, Native Americans and Asian, other European races that weren't necessarily as favored?
Sure. With regard to Native Americans, right after this, the 14th Amendment was ratified in 1868, there was a commission put together to ask the question, how does this apply to Indians not taxed? In other words, to Indians who live with their tribe as part of that political community. And basically they said, and some people who had written the 14th Amendment were on this commission, they said, no, we didn't mean it to apply to those. And they weren't denying U.S. citizenship to the Indians in a negative sense. This is the way the tribes themselves didn't want U.S. citizenship on tribal ground. They wanted to be their own sovereigns. So it didn't apply to Now, with regard, if there were immigrants that, people born on this soil, no matter what their heritage was, even if it was disfavored, would be US citizens, except for Chinese who were excluded from US citizenship a few years after that, that they were a group that legally, it wasn't until 1942 that people of Chinese heritage could become US citizens. Now, technically here, well, I'm sorry, they would be US citizens if they were born here, but Chinese immigrants could not be naturalized citizens until 1942. Because there was something called the Chinese Exclusion Act that they excluded them from the other laws of naturalization. So now this next clause, this third thing, nor shall any state deprive any person of life, liberty, or property without due process of law. Now, so you guys are studying the Bill of Rights. We're looking at it. This, this phrase, won't deprive any person of life, liberty, or property without due process of law. That wording is identical to what's in the Fifth Amendment, except that the Fifth Amendment was saying the United States government isn't going to deny due process. This is saying no state is going to deny due process. And furthermore, Section 5, Congress will ensure that states don't deny due process of law. And so it is the identical thing, only the Fifth Amendment was telling the federal government when it impacts people's lives in a big way, there must be due process. The state governments, backed by the force of Congress, must also provide due process. And then they also said, because of the Black Codes, nor deny to any person within its jurisdiction the equal protection of the law. Basically, they're saying these laws based on color are, that's no. And Congress can enforce this. Congress can if the Southern lawmakers are trying to do that, Congress can come in and with the legislation enforce and say, actually, you can't do that. So we're going to spend a lot of time this semester sorting out how the Supreme Court interpreted this first part of the 14th Amendment. But eventually, to talk about the story, well, we're going to look at two stories that come out of the 14th Amendment. The first story we're going to look at is the impact that the 14th Amendment eventually has on the Bill of Rights. Eventually, and I know this won't make sense right now, but we'll talk about it a lot. Eventually, in a piecemeal way, the courts would say that the due process clause eventually makes bits and parts of the Bill of Rights incorporated to the states or applied to the states. And if that doesn't make any sense right now, that's fine. But the other story that the 14th Amendment tells is one about the Equal Protection Clause and how the court eventually interprets the Equal Protection Clause. So from here forward for a few weeks, we're going to be telling two stories that come from the 14th Amendment, how it eventually came to apply most of the Bill of Rights to the states, and also how this whole new idea was introduced about equal protection. Now, interestingly, we do have this a due process clause in the original Constitution that applied to the national government, but there wasn't a similar clause about equal protection in the rest of the Constitution. So eventually a question comes, okay, well, states have to promise equal protection, but does the federal government? There's no such similar wording that applied to the federal government, but the court would say, yeah, they do. And we'll talk about how that happens eventually. That's the point where we're going to stop today. Does anybody have any questions? It has been lovely spending some time with you. And I hope you have a fabulous weekend. And I look forward to seeing you on Tuesday.
Have a good weekend.
Thank you.
Thank you. You guys take care. Have a good weekend too.